Number 38, the people of the state of New York versus John Stone. Counsel?
Good afternoon, Your Honors. Lisa Packard on behalf of Mr. John Stone. I'd like to reserve 2 minutes for rebuttal, Your Honor.
You may.
Your Honors, reversal is required. Of course, there is a reasonable possibility that the jury considered the detective's testimony that the defendant's ex-wife, an eyewitness, accused him of the offense. There is some evidence that is just too...
Let's assume for a moment it's error. Why isn't that cured by the instructions from the judge? Both striking, telling the jurors that when the testimony comes in, to disregard it, and then instructing them again on the full charge.
This particular evidence completely transformed the case. Some evidence is so powerfully incriminating that we cannot rely on
Well, how is that? I mean, the victim himself says that she's present. So you've already got sort of in the ether that she's present.
But this transforms the case from a one-witness, inherently biased witness, single-witness case into a two-witness case. And the reason why the Bruton line of cases is so helpful...
Well, it's not direct testimony, right? You're arguing that there's an inference to be drawn.
Implicit accusations still violate the Confrontation Clause.
But the question is how nebulous and vague really are these implications?
If any implied accusation was approaching a direct accusation...
Well, he said he spoke with her, and then he proceeded to check on
the person who had
Mr. Stone.
The person who had been indicated as a suspect, John Stone. It's almost...
Do you take that in a vacuum, or do you consider the other testimony that had been elicited regarding the investigation, how it unfolded?
Well, first of all, going to the merits of it, that doesn't change whether or not it's a Confrontation Clause violation. That's addressed in Ryan v. Miller, which is cited by this court in De Jesus. So it might change the prejudice, but the thing is that we have the detective actually testifying that he spoke with the night watch detectives, and after that he decided to talk to Rhonda Stone. He's not saying at that point that the night watch detectives told him that the complainant accused this particular individual. He says that he then went to Rhonda Stone, and after speaking with her, he ran computer checks on the person who had been indicated as a suspect, and everybody, the prosecutor below, didn't
why is
even
it you
make
can draw
this
the inference
argument.
you're talking about?
Pardon me?
But why is it you can draw the inference you're talking about related to the officer speaking to her and then doing a computer check on the defendant? And you can't draw the inference that apparently the judge is drawing, which is that officer has already spoken to the night watch team and already understands that Mr. Stone is on the radar because the complainant has identified him. Why can't you draw that inference equally as well as you draw the other one? So then aren't we in equipoise? You can't really say it's such a dramatic error.
Because the source and the content is clear. And so long as the source and the content is clear from the implicit accusation, even if there's potential other sources, it's still a Confrontation Clause violation. It's no less a violation. It might go to prejudice.
Can I back you up for a second, because we're talking about the Confrontation Clause? And can you point to me where in the record that argument was preserved as to this issue?
Yes, it was fully litigated. At the moment that this testimony is elicited, everybody knows what happens. Counsel objects immediately. He moves, the jury is directed out of the courtroom. He moves for a mistrial, explicitly referencing the prior litigation in which he had cited his client's right to confrontation, saying it would imply that there's a second witness, a phantom witness that I cannot cross-examine. That's at 179 of the appendix.
But wasn't that whole thing in the context of the people wanting to not allow him to question about where she is and talking about Trowbridge, and I don't see how it's really connected to this particular issue.
He's saying no reference whatsoever to Rhonda Stone should come in that would imply that she would corroborate the testimony. And mind you, this is on the heels of the judge already ruling, A28 of our appendix, that no background testimony of this nature can come in, where there's a question and answer series. He says, the judge says, this is so worn out. I don't want any background testimony coming in where you're asking the detective what he did before and after speaking to certain witnesses. The prosecutor pushes the envelope once again and says, I want to bring in testimony showing the police officer's efforts. And they extensively litigate it with defense counsel saying, this cannot come in. It's a second phantom witness that I cannot cross-examine, and it violates my client's right to confrontation. And then he references back to that exact conversation at the time of the mistrial. He says, we've gone to great lengths going back to that conversation. The judge understands exactly what he's talking about. Directing the jury out of the courtroom at that time to litigate
the distinction that I saw drawn in the objection and on preservation, not to spend too much time on this, but it seemed like you properly objected and mentioned Brady and right to confrontation in the efforts to locate Rhonda, I believe her name was, but that the same objection wasn't brought up when we're talking about McCrossan's testimony and what had happened when he originally spoke with her. That's the distinction I see drawn here.
The application had already been made. The court had already ruled this couldn't come in. And so
you're saying it was properly preserved in that context, then?
Absolutely. And then he references back to that conversation. He says, we went to great lengths to make sure that nothing like this would happen. The judge sort of disagreed with him about that, but he'd already made the application, and then it was completely transgressed. And the prosecutor was not disputing that at all.
Counsel, can we move off of this just for 1 second? Go back to something Judge Rivera, I think, raised initially. There's an objection. The judge sustains it and strikes the testimony and gives, I think, 2 at least, instructions to the jury. So it seems to me your claim of error is the mistrial motion. So we would have to find it was an abuse of discretion not to grant a mistrial. That's the error here you're claiming, right?
No, because he requested a mistrial. That preserves the confrontation question.
No, forget the preservation, but your error here is no mistrial.
Preserving the constitutional question entitles us to the constitutional standard for harmless error analysis. And that's...
I don't understand the harmless error analysis in this case, because the error is he didn't declare a mistrial. What could be harmless if that's the error? If he abused his discretion and didn't declare a mistrial when the judge had to declare a mistrial, what's the harmless error analysis?
So now the analysis is it possible that the jury still considered this evidence even with the curative? It's the exact same as it is with Bruton
Right, but
context.
that's a different issue. To me, the harmless error analysis is somewhat misplaced here, because to do a harmless error analysis on an error of not declaring a mistrial, you'd have to say, you know, and in the next trial he would have been convicted anyway. That's the harmless error analysis. To me, was this such an error, a grave error, that a jury is going to disregard the judge's instruction to strike and his instructions about how you can consider this, so that it was an abuse of discretion for this judge not to declare a mistrial, because everything short of a mistrial he gave to your client. He didn't say this was okay.
That's why we're here.
It would be harmless error if the judge overruled the objection.
But it's subsumed within the constitutional harmless error standard.
What's your analysis of harmless? If you're saying it was an abuse of discretion not to declare a mistrial, which is the only error here that you can claim, what's harmless error got to do with that?
No, the error that we can claim here is that there was a Confrontation Clause violation that deprived him of his right to cross-examine that witness
Such that a
and test the
mistrial was
reliability.
necessary.
Yes, such that, and the reason...
Right, so I think we're getting back to my first question, is why isn't, as Judge Garcia is pointing out, and I asked you before, sustaining the objection, striking the testimony, telling the jurors it's struck, telling them to disregard it at the time that it comes in, and then again instructing them at the time of the charge. Why isn't that enough? And it strikes me you keep going back to, well, it's such a severe error that they cannot overcome the instruction, and that's where we boil down to whether or not that...
That's right, and that's what's going on in Bruton. They're told to disregard.
Yes, and when I asked you about the context, you said, well, that's when it goes to the weight. So why doesn't that inform the analysis of whether or not the things that the judge did do, as Judge Garcia said, short of granting the mistrial, enough?
Because just
Sure
telling
that the defendant was not denied a fair
because
trial.
just telling the jury to disregard it is not enough when the source of the statement and the substance of the statement is so powerfully
But again, we're going
incriminating.
back. It's in the context, right? We had this conversation. You answered several questions from the chief and others in the context. And if you've already got to that prior testimony and it comes at a particular point in the trial, it may very well be that it's not the kind of egregious error that has the impact that you argue. And in that kind of a case, the curative instructions may be enough.
But I mean, this goes back to Carburano from 1950, that if we could always cure error like this by striking the testimony, then the prosecutors would have no incentive whatsoever.
How can you compare this situation where you say, okay, we had a one-witness case, and in this case it was yes, of course, an interested witness, a victim's always interested, but had a pretty good opportunity to see his attacker and so on and so forth. But compared to a Bruton situation, which is so powerful, how is this? I mean, this is, to me, seems like any other case where, okay, yeah, maybe there's some prejudice here, but why does this rise to the level of a Bruton?
This is an extremely unique case. The person at the scene was the defendant's
This
ex-wife.
happens all the time.
But not in the context of this. It's the source, the witness, the eyewitness that actually saw, was there, potentially present, knows the defendant better than anyone else. And it's not just that she's saying that he has motive. Sometimes Confrontation Clause error happens in the context of ascribing motive. She's specifically identifying him. It changes the entire case. This is the exact situation where we say that there are some contexts in which the
What
risk...
if it was, so if it's his wife, his former wife, or his mother, or his brother, or his sister, so anytime there's somebody that would know the defendant well, that's enough to make it a Bruton-type exception to the general rule.
Not Bruton, it's just that Bruton says that there are some contexts, and then it recognizes co-defendant-type cases as a class where we have to do that analysis.
Wouldn't your argument
But-
be stronger if indeed the testimony is that she had expressly identified him, which she didn't? You're asking for the inference. That's your argument.
Well, the
But
confrontation...
it isn't the stronger argument is if indeed the cop said, oh, and she identified him, so then I called him. And that's not what you have here.
I think it comes about as close as it could possibly be to that accusation. He says, I began to run computer checks on the person who had been indicated as a suspect, John Stone. It's just stated in the passive voice.
Then your point there is as soon as that statement comes out, it's a mistrial. There's no recourse other than a mistrial. And the case I saw, I remember at least one where that happened, I think the judge lets in a co-defendant confession that goes on and then says, oh, you know what, that was a mistake, strike it. And the court's saying, you just heard, an hour-long confession from a co-defendant, which should never have gotten in under Bruton. You can't instruct your way out of that. This is, okay, we even grant you the inference here, and the response from the court we have to find as a matter of law was insufficient and required a mistrial as soon as the jury heard that. Nothing short of a mistrial, as a matter of law.
All we have to find is whether or not there's a reasonable... There are things that could have happened after the court did not grant that mistrial motion that might have ameliorated the prejudice under the constitutional harmless error test. Perhaps counsel would have been allowed to bring in the fact that she had redacted her statement, or that her initial...
Did he request that? Did he request an opportunity to do that?
He probably didn't want to draw any more attention to her absence, but moreover, this is what makes it so unfair. The prosecutor had already secured his promises that he wouldn't make any references whatsoever to her absence. So they get the best of both worlds at this point, because this statement that ends up coming in might be far better than any statement that she actually would have testified to. She'd come to the prosecutor's office just the week earlier to say, I didn't see him, I couldn't see anything. There were people standing in between me and the assailant, and moreover, there was no statement that I recall from that incident. Defense counsel also points out that there were no scratch notes taken at the time of the initial interview. So this particular officer's testimony is also potentially unreliable, and then compounding that error is that defense counsel has no right to cross-examine him. And so it's a nightmare scenario for defense counsel. It's best case scenario for the prosecutor. Considering the harm of this statement, there'd be virtually no incentive for prosecutors going forward to not transgress these rules, resting assured that so long as some curative instruction is given, that the verdict is safe on appeal, and completely eviscerating that protection.
Thank you, Ms. Packard. Mr. Spolzino?
Good afternoon, Your Honors. May it please the Court, my name is Robert Spolzino, and I represent the people on this appeal. There was no abuse of discretion here in denying a mistrial. The reason for that is that there was a curative instruction given, and that the testimony itself was not inherently a violation of the Confrontation Clause. There was no clear inference in this testimony that the person to whom the detective had spoken.
I think it's a fair inference, though, right? It's a fair inference.
The legal standard is a clear inference, Your Honor.
But it's pretty clear.
Well, I
But
respectfully.
assuming that's the case,
Okay.
let's
Respectfully, I
assume
disagree with it, but assuming that's the case.
Understood. But why isn't what the judge did enough in that case, then? I mean, isn't it, you get an instruction, you get the testimony stricken, this is about a mistrial or not?
That's correct, and the judge did enough here.
Because even the judge thought the inference was there.
Right, and that's particularly true in the context here of this entire trial. This was, the defendant's argument rests on 5 lines of testimony, or 5 lines of the transcript in this trial. There's a whole rest of a trial here where the victim
If
had.
those few lines allow the jury to infer that his own estranged wife ID'd him as the perpetrator, it's pretty damning. And
Respectfully,
he
I'd-
doesn't get to cross.
Respectfully, I'd say no, Your Honor. Here's why. First of all, the jury had already heard from the victim who had identified the defendant. And this was not, I know it's technically a one eyewitness ID case, but it's not your classic one eyewitness ID case where the eyewitness has never seen the defendant before the incident. This is someone who knew the defendant for years. Not well. He was the ex-husband.
Well, he never met him. He
but
saw him in profile. There was a hoodie that he said he removed.
he had seen him on a regular basis, and they at least had one face-to-face confrontation. So this was not just someone who saw him at the time of the incident. So this is what the jury heard, right? So now the detective gets up to testify, and you look at this in the first, this all occurs in the first page of the detective's testimony, where he's simply reciting what happened here. What happened was, I spoke to the detectives on the night shift. Now, we also know from the victim's testimony that he had told the night shift detectives, he had identified the defendant when he was at the hospital.
Well, the record's not so obviously clear on that, but let's assume you're right.
The night shift detectives told the detective, McCrossan, that there was a victim at the hospital and told them which hospital it was at, right? So the first thing he says, I talked to the detectives, the night shift detectives. What did you do next? I talked to Miss McClanahan. After that, what did you do? I ran a check on the defendant who had been indicated, on the person who had been indicated as a defendant, John
The
Stone.
suspect.
As a suspect, John Stone. Okay?
But he was a suspect based on what he was told before he spoke with her. He could have started the computer check at that point, right?
But he could
Isn't that
have,
what the jury's thinking?
But he was testifying to a sequence, and that's all the jury heard at this point.
But that's my point.
The jury didn't know.
But that's my point. Doesn't the sequence suggest that it's because she also ID'd him? Because otherwise he would have done the computer check before speaking to her. I mean, no one's spoken to her yet. The man was stabbed many hours before this.
I don't know if that's a fair inference, Judge. He's just saying what he did. He's not implying that he did. This wasn't a question as a result of speaking with Ms. Clanahan, what did you do? This was after I spoke with her. What did you do next? That's legitimate questioning about what the police officer did, and it doesn't shed light one way or another on why he did it, it certainly doesn't raise the clear inference.
Are you
that that's why.
arguing that it's not error, or that it's, I'm a little confused here, that it was an error to
I'm trying
allow?
I'm trying to argue on several levels, Judge Stein. The first being, it's not an abuse of discretion not to declare a mistrial.
Because it's not error?
Because it's, well, that's part of it. But the other part is it was cured. Even if it was error, it was cured. But I'm submitting it's not error at all. Because I think that given the testimony here, the inference wasn't there.
If, as I had asked your counsel for the defendant, if instead the officer had said, based on what she said, I then did a computer check, can you cure that, or does that require a mistrial?
I think you can still cure that by
Doing what the judge did here, or do you have to do something else?
By doing what-
Apropos of what she suggested.
doing what the judge did here. You don't need to declare a mistrial over that one statement. You can cure it by saying, disregard this.
So then at what point is an error of the kind that's not curable if having the estranged wife ID the defendant as the perpetrator of the crime, who is then a witness, the defendant doesn't get to cross, not the kind of error that lets you do that? That sounds very much like the co-defendant identifying him, no?
Well, I would submit it depends on the extent to which it's a focus in the record. Judge Garcia mentioned the case where there's an extensive colloquy about the confession, right? I think if it's something that passes through the record quickly without any clear implication, maybe there's an inference to be drawn, I dispute that, but certainly without a clear implication, I think you can cure it with a curative instruction, and that's the situation here.
Can we turn, Mr. Spolizino, just for a second to the 33030 motion?
Yes.
The second issue, and counsel maybe can address it in response when you come back up. On that issue, the way I understand it is the victim's girlfriend sees, not the victim, the defendant's girlfriend sees the victim saying something to the jurors post-trial. And the question is whether or not the court was able to deny the motion without a hearing. That's the way I see it. So the way I understand what was said, I'm not going to quote the words exactly like, but he said something like to one of the jurors that you're my man, or that's my man, and thanked other jurors. And so we got either an expression of thanks, the words either mean that, or an acknowledgement of friendship. So that seems to, if a statement can be taken two ways, isn't the court under an obligation to hold some kind of a hearing to make that determination? That's the first part of my question. The second part is the thing I want you to address, if you could, too, is the affidavit came from the lady who had seen it. Her name was Anderson, I believe. And if you assume that what she said is true, wouldn't that also get them a hearing without any other corroborative evidence? I mean, you don't necessarily have to have a juror, and you certainly don't have to have a court officer, say, to get this kind of hearing. So would you address those for me?
Yes.
You got it first, all right.
Judge,
First, the words themselves, assuming them to be true, well, you can do it in once, and if Anderson said it's true, how does that ambiguity in the statement not create a hearing issue for a factual determination to be made?
Because I think there has to be something more clear than an ambiguity, than a statement that could mean some prior relationship, but doesn't necessarily mean some prior relationship.
Well, we're talking about getting a hearing to make it a factual determination. What do you need to get a hearing then?
I think you need something more direct than some offhand comment that doesn't necessarily imply that there was a prior relationship. If the comment had been, yes, saw you last week, good to see you again, that would be a different story.
Well, what doesn't imply that the complainant and the juror knew each other if the complainant is specifically saying, not just a greeting, but saying, when I came in and I saw you there, I thought, oh, there's my man.
But that's not what he said here.
Okay, what did he say?
He
Without
said,
using the expletive, you don't need to use
There's
it.
my man, or something like that. It wasn't something that referred to any past relationship at all. It said, you're my man.
I remember it like Judge Rivera does, Mr. Sposino. I remember it a little bit differently, but,
I'll find it.
you don't need to look it up. You don't need to waste
I've
your
got
time
it
with
right here, so we don't need to belabor this. The fiancé who signs the affidavit says, the complainant went up to the group of jurors, went up to a particular juror she identifies, and grabbed his hand and stated, "Yo, when I saw you sitting there, I was like, oh, expletive, that's my," I'll replace the word man.
Right.
"When I saw you sitting there," they're in the street standing up, so he's not referring to the moment they meet on the street. This is clearly a reference to when he came in and saw him in the jury box.
I
mean, doesn't that at a minimum get you the hearing? Because
I would-
in the complainant's affidavit, he doesn't say, "I didn't say that."
He says he said something completely
He says
different.
he said something else, but he doesn't say, "I
Right.
didn't say that also."
Yeah.
He's not denying he said these words. He is absolutely saying, I did not know the juror before then. I understand that.
But I don't think, even when it says, "I saw you sitting there," I saw you sitting in the jury box, "you're my man," to me implies that I was confident you were the guy that was going to find the conviction, not that I
Based
had
on
prior-
what? If I don't know anything about you?
Based on looking at him, based on
And that would be
judgments.
based on what?
But
Isn't
it
there
doesn't-
also a racial component to this case, right? I mean, there is something said during the time of the attack, right? And I took that as it could have been also, if you're looking at an ambiguity, that I think they were of the same race, these two there. That's my man, you're gonna help me. You could take it as that, you know, the victim and this juror.
It may well be. It may be that, or just from the way
Even
he
more
he
reason
looked
to
at him.
explore this in a hearing.
Well, but the basis for the request...
Suggesting that this complainant, upon viewing the juror based on race, which is actually not what the fiancé says, because she says he's Latino. I don't think the complainant's Latino, right? Isn't that more reason to explore this?
But the basis for the 330 motion was that this comment suggested a prior relationship that had not been disclosed between the victim and the juror.
I agree with you. I think it's kind of weak. I'm only wondering why there wasn't a hearing, not how I would rule if there had been a hearing and we had some kind of a record. You just asked those questions. What did you mean by that? Did you ever meet him before? Ask the juror, do you know this guy? Those are, see, you know, sometimes you approach the language that you read. I'm a 65-year-old white guy from Western New York, and my grasp sometimes on language that, more colloquial language in various other parts of the community, I don't know it. I'm not sure what it means sometimes. And so if I'm a judge, I'm sitting there saying, well, okay, I'll ask the question. What do you mean? And it seems to me a pretty reasonable question to ask.
I would just submit, Judge Fahey, that if the standard were low enough that this would trigger a hearing in a situation like this, any
Well, that may be
defendant
true,
could get a
but
hearing.
it's the thin edge of the wedge argument, Mr. Sposino, and we're confronted with that all the time here. It doesn't necessarily, though, change the facts. You see what I'm
Well,
saying?
the
I
people
understand
could have
what-
had an affidavit from the juror.
Perhaps, but they didn't, and it's the record we're stuck with. Thank you, Your Honor.
Thank you, counsel. Ms. Packard?
So I just want to go back to the question about mistrial versus the standard
Before
that,
you do that, I just want to follow up on the last question about the fact that the people could have gotten an affidavit from the juror. Whose burden is it on this motion?
The
It's the
burden-
defendant's burden, right?
the defendant's burden is to allege facts, support sworn allegations
Right,
of
so
fact
it-
and a legal basis.
So if what was necessary to get this to a hearing was something more than just the report of this somewhat ambiguous statement, it's the defendant's burden to provide that something more, correct?
They met that burden by
Well,
providing,
I know, that's the question, whether they did or not, but the burden is on the defendant.
that's right.
Okay.
Isn't what's troubling here that the version of this interaction from and you'll correct me if I'm wrong, from the fiancé is that she was with other people when she saw this? Is that not what she says?
That's right.
And they're family members of the defendant, are they not?
I believe so.
Okay, and the defendant didn't get their affidavits to support her and corroborate her. Doesn't that perhaps put her
There's an issue-
statements in a different kind of light?
there's an issue of fact. We don't know why the prosecutor didn't bring.
And you might have an argument the juror perhaps is unavailable, unwilling. I guess the lawyer could have said so in his statements to the judge.
The observable conduct that they're both putting in their affidavits, their sworn allegations, is enough to create multiple interpretations.
You're saying it's a credibility question that goes to the hearing.
Yes, exactly. And so.
Does it matter that the judge observed the complainant and the juror the entire time? Throughout?
No, because we don't know what this means. And the legal basis is outside influence. They don't have to prove anything. They just have to support it, that there's some fact out there that actually supports that legal claim.
Well, then,
And unless the people
if we
can-
agree with you, does that mean that any defendant can just find someone who will say, this is what I heard, and we're going to end up with a bunch of hearings? You're always going to end up with a hearing? It's a pretty low threshold you're setting.
I mean, submit them to a potential perjury. I mean, it's a sworn affidavit that's provided by her that she's saying she saw these observations.
Well, obviously, that's the judge's conclusion here, since he says what comports with reality is the complainant's affidavit, not hers.
Well, or perhaps he just wanted to credit it and not grant a hearing in this particular case and belabor it, but it has implications beyond 33030. I mean, we have other contexts in which a hearing has to be granted. I do just want to note the preservation question, which is that this court in People v. Smith, which was cited by my adversary, addresses that we're still entitled to that constitutional harmless error standard once it's preserved. And so the abuse of discretion is subsumed within that. So the question for this court is, even with the curative instruction, and Bruton says that when you have a powerfully incriminating statement based off the source and the substance that completely transforms the case, and it's too much to ask the jury to put it out of their minds, that, of course, there's a reasonable possibility that it contributed to the verdict. And, you know, that's not all that we have going on as a biased witness. We also had the jury asking questions about the particular circumstances of the identification by the complainant. It was at nighttime. It was a side profile view from 11 feet away. He was wearing a hooded sweatshirt. He was attacked from behind. He was a mere acquaintance.
But if they're asking that, doesn't that suggest that they're really basing this on whether or not they believe him, that they don't see that there's some other inference to be drawn from the police officer's slip?
The inference to be drawn is that Rhonda Stone was there and she identified him.
Yeah, but I'm saying the more you're going to worry yourself about the complainant's ID, it's very clear what the complainant has said. If she, the estranged wife who you said, knows him better than anybody.
It shows that there's not overwhelming proof of guilt without that error, and that's why it's so problematic. And, you know, even under the non-constitutional standard, we have Garcia contemplating that an eyewitness who is even less compelling in that case does not.
Do you have curative instructions in that case?
It was admitted, the jury heard it, and there were no limiting instructions, but the point is that the jury heard it. And so does that one instruction to disregard the testimony answer the inquiry? No, not when the statement is so powerfully incriminating. That's why procedurally the Bruton cases are helpful.
Thank you, Ms. Packard.